Welcome to Tangents from Coin Center. I'm Jerry Brito, Executive Director of Coin Center, and with me, as always, is Peter Van Valkenburg, Director of Research at Coin Center. Hi, Peter.
Hey, Jerry. It's nice to have an episode, even though we don't have much to talk about. I was just missing you, so.
Yeah, we just decided to do one to go through the motions. So as you can imagine, folks, we're going to be talking about tornado cash. And this morning we posted a full analysis that we did on the statutory authority that Treasury cited when sanctioning tornado cash, and we'll get into what that means exactly. And we thought we'd go through it. And you know what we like to do on this podcast is maybe break down our mumbo jumbo legal arguments for non-lawyers.
Mm-hmm.
And so maybe the first thing to do, Peter, is to go really basic and just explain that when an agency takes an action, right, especially one that affects the public or individual persons, they need to cite exactly what law that Congress passed gives them the authority to take that action, right?
Yes.
And so in this case, when OFAC did what it did, what did it cite and why? And what does it say and all that?
So when OFAC added the tornado cash designation, they cited an executive order that came out during the Obama administration, which is generally referred to as the Cybersecurity Executive Order.
The Cyber Executive Order is what I heard.
Right, the Cyber Executive Order.
Yeah.
And then that executive order, for its authority, because the president isn't allowed to just create orders about whatever they want, sua sponte, cites two laws that were passed by Congress. One is the National Emergencies Act, which allows the president to create national emergencies or designate national emergencies and then take action in response to that.
To be clear,
not to create national emergencies. Some presidents do probably, but
yeah, the president can declare a national emergency.
Declare a national emergency. And so, under this power, President Obama, recognizing like hacking efforts from North Korea and Iran and things like this, created a cyber order, which said like there's these foreign elements that are using the interwebs to get at our critical infrastructure and things like this. And so we need these emergency powers. But the NEA doesn't actually describe that many powers aside from the ability to declare a national emergency. It basically opens up this other existing area of executive powers, which is sanctions law, with respect to that emergency. So those other powers come from a law passed by Congress called the International Emergency Economic Powers Act, the IEEPA, or as we tend to call it, IEPA. And IEPA has evolved from a statute that goes all the way back to the early 20th century, which is the Trading with the Enemy Act. Might even go beyond the early 20th century into the 19th century. And this is a law that, like, in its original drafting, the Trading with the Enemy Act is like, if you capture an enemy ship, you can seize it. The government can seize it and can seize all of the tackle attached to the ship. So you don't have to give the ropes back. You can keep the ropes too. Like that's how old this stuff is. But basically, it's about a fairly unrestrained power of the executive during wartime or emergencies to block, nullify, freeze, claim the property of an enemy state, of a foreign national, and these sorts of things. And so what's going on here is we've got previous evidence of the Lazarus Group in North Korea hacking, doing ransomware attacks, raising lots of money, potentially using that money for its nuclear arms program, really grave stuff. They go and they want to launder their money. Often it's ransomware, so often it's already Ethereum or Bitcoin or something like that. They go to mixers like blender.io, which was subject of one of these OFAC actions last May. Blender.io mixes it for them. And then the president, seeing this, or the National Security Commission or whoever, probably talk with OFAC, and OFAC's like, yes, we should sanction blender.io as well. And so then they use their sanctioning powers to sanction the Lazarus Group. That happened, I think, in 2019. They use the OFAC powers to sanction Blender.io. And what they're saying is Americans under our authority in IEPA are no longer allowed to deal in the property of these foreign nationals, including, for example, using Blender.io services in the future, but certainly including like giving money to the Lazarus Group or collaborating with them in their hacking efforts. So that's sort of a rough rundown of both
so
what's at stake and what the statutory grounding is.
So let's keep going step by step. So, okay, so what OFAC cited for its authority to designate tornado cash, into the SDN list, and we'll talk about again what that means later. They cited the executive order and IEPA.
Yeah, and the executive order at its very first paragraph says, with the authority granted me in 50 USC 1700 et sec, which is IEPA, I am going to do the following in the case of this cyber emergency.
And so they cited that authority. Okay, great. What does that law passed by Congress? What authority does it give OFAC? As far as, well, correct me if I'm wrong, but the authority it gives them is, number one, it allows them to designate persons. And then persons is defined. And it allows them to designate persons who are foreign nationals. So there's two things here, right? And persons means individuals, but it also can mean entities. Entities is also defined. An entity, and entities means everything that you imagine, right? So companies, corporations, associations, et cetera, et cetera. So things that are basically,
in theory, unincorporated organizations are just fine. I think groups is one of the. So it doesn't matter if you didn't file to become a Delaware company or something. If you're a group of people that are obviously working together to do something, like, say, I don't know, Al Qaeda, you're eligible.
So essentially, you have to be an individual human or a group of individual humans.
Yes.
Number one. And number two, you've got to be foreign. And there's a question about, what does that mean? Does that mean you all have to be foreign, or 51% of you, or whatever? But the point is, there's got to be a foreign element.
Well, it's kind of interesting. And just to nerd out on something, that the NEA is the National Emergency Authorization Act. But the powers that it gives the president are the International Emergency Economic Powers Act. And so the NEA is about national emergencies, but what powers does it give the president? It gives them powers with respect to international properties that some foreign country or national has an interest. That's actually the language from IEPA. So, it is a statute that gives you powers to deal with national events, emergencies, but it's still limited. You can't just start seizing Americans.
Right.
An ordinary American's own personal property under IEPA. You might be able to do it under some other statute, but IEPA is about foreign persons. And this is important because that changes the level of constitutional scrutiny and the kind of constitutional rights that someone who's had their property frozen or seized or their liberties curtailed have, because we don't typically give the benefit of our Constitution to foreign nationals.
Or to non-U.S. persons.
To non-U.S. persons, yeah.
And a difference there for folks who care is, you can have a foreign person on U.S. soil, right? Maybe because they're a tourist, they would get constitutional protections. It's just non-U.S. persons. Okay. So what OFAC can do under the authorities it cites is designate a person, and then they can freeze or block property belonging to that person, or property in which they have an economic interest or a property interest, or however it is.
I mean, to be pedantic, it's a laundry list of adjectives to make sure that you can't argue that, oh, that's not a block, that's a this. It's nullify is in there, freeze is in there, block is in there. So, yeah.
Okay. And so in a normal case, you identify John Doe, who is a Frenchman, and you put him on the list. And then you might also put on the list, and this is to me kind of again, not to get too tangential, but the nature of the list. Yeah, you're right.
This is tangents.
Yeah. The nature of what the list looks like, I want to return to in a minute. but you put John Doe on the list. You might put what his aliases are, right? John the Jackal, right? Whatever else he goes by. You might even,
Yep.
AKA.
And in fact, sometimes you have only weak, what are actually called by OFAC weak aliases, i.e., ones that if you were to run through a screening database, everybody going through TSA would suddenly be stopped because it is a name that's common, like John Smith or something.
Right.
And so they have the alias, but they put it in parentheses and they put it in quotation marks.
Right.
Yeah.
And they might list on there as well things like an address, right? Like maybe the name of a boat.
Yeah.
Or something, right?
Like doing business as a vessel, web address, a Bitcoin address.
A Bitcoin. Okay. So, and so then what this does is that it creates an obligation on the part of all Americans not to engage with or transact with these people, but very specifically, it doesn't mean you can't talk to them. You can't deal with with property that they have, right? So their property is frozen, right? You can't buy their boat. You can't sell them boat paint.
You couldn't even buy an interest in their boat, like some fractional interest or what have you. Or you probably couldn't trade a synthetic derivative based on that thing as the underlying. That's a really abstract thing where you're not really, but you're using that as something in a financial contract. That's probably the most abstract that it would get.
Yeah.
But you're right. You can call a phone that's on the list and be like, hey, who are you? If there was a phone number there, you could call them. You could be like, how's it going? What's up?
Yeah.
And there's actually even in IEPA an amendment called the Berman Amendment, named after a congressman who insisted upon it, that says that none of this can apply to things like the distribution of art, music, literature, including CD-ROMs. It even if they're embodied in physical media, and this was the 90s, so CD-ROM is in there. I think like floppy disk might be in there, things like that. Yeah.
Okay. So then, what is the next thing I want to say about this? Well,
one thing I would say is to make this a little less abstract and start bringing us towards an actual case with cryptocurrency. The first time OFAC did anything was in 2018 with respect to cryptocurrency.
Yeah.
And there were two Iranian nationals who were, they're in an enemy state. It's Iran. They're sanctioned individuals. They've been engaged in cyber attacks, actually. I think it was. This is before the cyber order, but I think it was still, cyber stuff that they were doing. But they were in Iran. So even if it's not cyber related, it would be part of the sort of like
the Iran sanctions.
Iran sanctions. And OFAC said you're not allowed to interact with them via their Bitcoin addresses, which OFAC, I think, is identifying as their property. And that's right, because these Iranians were receiving Bitcoin payments at these addresses from their ransomware. And so in a very real sense, these are the Bitcoin addresses of Iranian people who are sanctioned, who are committing crimes. Right.
And so
really not controversial to me.
Yeah. The one thing that I'm not sure OFAC has ever explained, not that it matters, but I'm not sure it explained, is when they add Bitcoin addresses to the SDN list, are they saying that those Bitcoin addresses are people? No. Are they saying that those Bitcoin addresses are the aliases of people? Potentially. Mm-hmm. They could also be saying that these are these Bitcoin addresses are the property.
Yeah.
Okay. But I'm not sure they are clear about that, because there's two ways you can look at it. Maybe it's both and one and the same, but they could be either an alias for an Iranian, right? So essentially Bitcoin address is an identifier, right? It's an identity at which you can receive, you can use to transact, but because only you have the key, you should be the only one who has the key, presumably. That's sort of an alias for you. Mm-hmm. But it could also be, any Bitcoins associated with this address are your property.
Right. And it's a way to then identify the property. Like a vessel that's named Salty Maria is an alias for your property. It's not an alias for you. Yeah. And so, you could think of it that way, or an identifier for your property.
Interesting. Okay. Yeah. Okay.
HMS Salty Maria.
So, okay, so let's then get to, so they have previously added Bitcoin addresses to the OFAC list. I think they later added Ethereum addresses too. In each of these instances, the crypto community, noted it, but didn't, raised no objections.
No, yeah, because it's a fairly straightforward application of laws.
There's a person, they're foreign, there's property.
Yeah.
Okay. Then in May, so a couple months ago, as you said earlier, Treasury added a Bitcoin mixing service called blender.io to the SDN list. And they put out a press release explaining, this is for the first time, they are sanctioning a mixer, i.e. blender.io. And they say that North Korean hackers use blender.io to launder funds, etc. And what they did was, if you look at the designation, again, it has the name of the entity, blender.io, parentheses, aka several, Blender X, Blender, whatever, right? Several things. Then it lists several websites associated with that entity. And then it lists a bunch of Bitcoin addresses. And presumably these are the Bitcoin addresses from which one would send and receive Bitcoins to mix. Again, what was the reaction from the crypto community when that happened?
Neutral. No. I mean, there's discussions to be had about whether sanctions policy is the right way to do foreign policy, but that's a discussion that anyone could have, not just a Bitcoin person.
Yeah, So, and the reason for that again is you have an entity, you've got their foreign, and there's property that's being blocked.
Yeah. So and again, this is another time to highlight, like, we're not out there trying to make arguments that, like, because I don't think Blender was an incorporated company in some jurisdiction. I don't think it was. I think it's just,
who knows? Maybe it is in Russia.
Well, no, but I'm saying it doesn't matter.
Yeah,
because even if they were just a group of people, we're not contesting this claim that I've seen some people think we might be contesting, that, like, oh, well, a bunch of cypherpunks on the internet isn't really an entity and so can't be subject to sanctions. We're not saying that.
Yeah.
And Blender, like, again, the fact that we didn't react to Blender, no one else really reacted to Blender, kind of underscores that, because they were, I'm pretty sure, just a loose affiliated group of folks who all had control over Bitcoin addresses that they were mixing funds in, but they had control over those addresses.
Yeah. I'm not sure how loose they were. I mean, it could well be a company run out of a building out of, some country that doesn't, respect U.S. law, but it doesn't matter. The point is, point stands. Okay, so then let's get to Tornado Cash. So when OFAC announces its designation, what is striking to me is that they do so in identical fashion to Blender.
Yes.
And so if you read the press releases, you put them side by side, they're similar, almost identical, right? And so they basically say, today we are designating a mixer, Tornado Cash, to the SDN, to the SDN list.
In fact, the Tornado Cash press release even mentions a lot of text verbatim, or they even point to the Blender press release. Blender Act. They're like, we're just doing this again.
Exactly. Once again, we are sanctioning a mixer, giving the impression that these things are the same, right? You've got a mix. It's part of the problem here is, what is the definition of a mixer? Well, if you look at Blender, you could say that a mixer is a company or an entity where they take custody of your funds, they mix them, and they send them back to you. But that's not what Tornado Cash is. So they said, okay, we're press release said the same thing. If you look at the designation, very similar. The entity name, Tornado Cash, then parentheses, aka Tornado Nova, Tornado this, Tornado that. Then a website address, and then a list of Ethereum addresses.
Yes. About 43 of them.
Something
when I count, it seems different.
And this time, the crypto community erupted in objection. to this. And so what is the difference here? Well, the difference is that when you look at that list of addresses, there is a subset of those addresses that we can say is not a person and is not the property of any person. Okay. We can't say that about the balance of the things on the designation. So the entity name, the address, some of the other addresses, those may or may not be entities or persons. Yeah. But as to a subset of the addresses listed,
that's about half. There's 21 that we're confident in our identification, and we've worked with at least 3 now solidity experts who are like, their job is to audit smart contracts and make sure that the person who wrote them didn't make a mistake. So they know how these things work. They can look at the raw smart contract on the blockchain and tell you with more assurance than anyone else exactly how it operates and what it does.
The kind of people who would be expert witnesses at a trial, for example.
Yes, the kind of people that would be expert witnesses in the trial. And at least 21 of these addresses is what, we sometimes maybe in a sloppy way refer to as immutable. There's a contract code there that is deterministic. It's math. It does what it says on the tin. You send ether to this address, something's going to happen to that ether, and all of the choice as to what that something is written out in the code. And not only that, there's no person or group of persons or even DAO, i.e. people voting with tokens, who can update that contract or update parts of that contract or change it at all on the Ethereum blockchain. And that role is sometimes referred to as like an administrator or an admin key holder or a controller or an operator. There seems to be no standard terminology on Ethereum smart contracts. To be clear, several smart contracts on Ethereum do have these admin type roles. And that means there's either one person with a key who, by making a cryptographic statement with that key, can completely change the contract in the future. Or there's a multi-sig, several people with keys need to vote to change the contract in the future. Or there's even, smart contracts that are governed by DAOs, wherein a majority token holder vote allows the contract to be upgraded. And this is not one of those cases. This is a case where there either was never an upgradability role defined, which we would call no role. So the contract was just written with no ability to ever upgrade it. Or there was a role. And at some point, whoever had that role used it to upgrade the contract to provably destroy that role by saying, now the upgrader or the person who will have admin control over this contract is something called the zero address, which in Ethereum is a term of art for 0x0000000000. It's a public key correspondent to a private key, but because of its non-randomness, its clear artificiality, we can know with astronomical certainty, not absolute certainty, but like longer than the heat death of the universe, that no one could ever have generated the private key that matches that very regular looking public key. And so we can know with mathematical certainty that that contract is not upgradable, that no one has the ability to suddenly change the way the funds get mixed by that robot, or redirect the funds, or shut the whole thing down by deleting the contract. It's going to be there forever.
It's going to be there forever, and there's no way that the smart contract can decide who to service and who to not, right?
I mean, no more than a vending machine could, fall on people when it wants to not sell them Coke, it doesn't.
And so this is, I think, what is tripping up some folks who are reading our analysis. And it's completely understandable because there's a lot of nuance here. I think there's 2 levels to the nuance. One is OFAC essentially designated in one thing that they call the tornado cash designation, right? They designated, or they listed, a set of identifiers that we think may well be individuals or group of individuals. So wholly within.
Yeah. And to be clear, those addresses, which we've had folks look at, in addition to the 21 I mentioned that are credibly non-updatable, they're either not addresses involved in the mixing.
Yep.
In which case, this isn't even the mixer. There are like things like a Gitcoin donation address, where you, as someone who just wants to see more Tornado Cash-like software in the world, could probably donate. I haven't looked at the original GitHub Gitcoin listing, but I think that it was like, hey, if you like this thing, the software that allows people to have privacy, you can donate to the developers.
I think it's probably where the developers received Gitcoin grants that were decided on through the Gitcoin process. But yes,
exactly.
Essentially, it's just a donation receiving address.
Donation address. And so, yes, that would be the property of an entity. Now, whether that entity is engaged in something that warrants sanctions,
that's separate.
Well, it's separate, but it's important because it's not like Blender.io, where not only was that the property of an entity, it was the property that was explicitly used by that entity to do something that is illegal under FinCEN rules because they're not a registered money services business and they're taking custody of funds and mixing them. In this case, it's just a donation address. And the other addresses where some sort of admin level control remains, this is not the kind of admin level control that gives them the ability to redirect funds being mixed. It may give them the ability to shut down the contract in some cases. It may give them the ability to tweak who the contract services, but it's still not anything that would rise to the level of what FinCEN defines as a custodial mixer, which is another area of law. I'm not saying that means that OFAC doesn't apply. Right. I'm just saying that this is all of the addresses are very different than Blender.io. And the subset of 21 are entirely different in the sense that they're not even the property of an entity who's a foreign national and subject of sanctions.
Yeah. So again, I totally take your point, and I think what you're hinting at is, as I was saying, there is a subset of addresses that may well be the property of individuals or may be aliases for people. But I think what you're pointing out is that even in that case, those people, if they wanted to bring a court challenge, might have all kinds of defenses to make, where they could say we're nothing like what Blender.io was.
Chief among them, free speech. I think several developers are Americans. I'm not going to be specific as to who. And so they have constitutional rights. And if all they did, I don't know the facts, but if all they did was publish software that allowed other people to independently use it at these 21 immutable addresses to mix their own coins, to have their own privacy, then there's a very strong First Amendment defense that, like, look, you're taking highly aggressive legal action against me. It's damaged my reputation. It's caused businesses to close my accounts and delete all my code. I can't even get a bank account now because I'm associated with a sanctioned entity. And yet I'm an American. I have free speech rights, and all I was doing was publishing code. So that's an argument for them to make, hopefully with the help of great organizations like the EFF and who knows, maybe Coin Center when we learn more about the facts. But that's different.
That's so again. So that's one set, but then there is this other set of addresses also included in the totality of the designation that on which our analysis focus. And these addresses are certainly not people. They're smart contracts on the Ethereum blockchain, and they're not the property of anybody because they would fit no definition of property, whether legal or colloquial. They're literally robots instantiated on the Ethereum network.
They are logic. They're a series of ones and zeros that do what people want them to do.
Yep. And to the extent that there's property associated with those addresses, it is the property of the users of the smart contract.
So if you put money into one of those 21 addresses, it's not as if you've given money to some foreign national who has control over it and will do something with it. Not at all. It's not as if you've even given it to anyone, because the only person who will ever be able to control that money once you send it to that address is you. Because what that address does is it gives you a zero knowledge proof that says that you put X amount in, and you can take that proof back to that contract and say, I'd like to take X amount back out.
There's very little difference between having 1 ETH at the Tornado Cash smart contract and having 1 ETH in your own wallet.
No, you have a different type of cryptographic signature to create.
Yep.
Instead of a typical elliptical curve digital signature algorithm, this is my private key, I'm signing a message with it. You use the note given to you by the contract when you deposit it into it, which is another cryptographic hash. It's a zero knowledge proof that says, yes, this address put some in the past, but it doesn't tell you what the address is because it's supposed to be for privacy.
Right. And so to the extent there's any property associated with those addresses is those of the users of Tornado Cash, and these people are not on the sanctions list. Never designated. Okay.
I mean, presumably. Some of the users
might be. Yeah. In which case,
but there's definitely Americans who've done nothing wrong.
Yeah.
And I don't want to be like the lady doth protest too much, but they've really done nothing wrong. They're just ordinary Americans trying to use Ethereum without revealing their every transaction to the public.
Yeah.
And we have money in that address and now can't take it out.
Yeah.
Without putatively violating OFAC sanctions.
So that's one aspect of the nuance here is that there are really two sets of things in one designation, and I'm not sure if OFAC realizes that there's two things here. I think they treat them as just one thing, all associated with certain specific people, but these are not. And then the other piece of nuance that I think people don't seem to get or have trouble understanding, understandably, is that subset that we're talking about, by virtue of everything that you discussed about how the administrative keys were burned and these things are now, loosely termed immutable, nobody can change them, right? So nobody owns them, nobody can change them, including, as you were saying, any DAO, any token holder of any kind, any person.
Yep.
So that's just something. That's the feature of blockchain technology that I think it's hard for people who are not familiar with it to wrap their head around.
Specifically a feature of Ethereum in this case, although Ethereum's not unique here, but it's a little different than Bitcoin. And I think this might sound like weirdly metaphysical. It's like, well, you keep saying they exist independent of control. Where do they exist?
Right.
The way Ethereum works is if I was on this laptop now, which would probably start overheating because the Ethereum blockchain's gotten so big. If I had a powerful computer, turned it on and said sync with the Ethereum blockchain, part of what I download will be this contract. In fact, if I choose not to download this contract, but I download the rest, I'm breaking consensus in a fundamental way with the rest of the Ethereum network. So this contract does exist all over the world outside of the control of whoever might have written it originally or any particular foreign national. And it's not just in one place, it's on the computer hard drive of every person who syncs with the Ethereum blockchain.
Okay. And so given that that's the case, those are the facts, let's apply our statute. Is it a person, or is this subset of things we're talking about a person? Nope.
No, unless we want to recognize a new form of legal personage, the Ethereum
smart contract. Yeah.
In this case, I do not advise that as a public policy choice.
Is it the property of a person? We don't think it is. No. Okay. Therefore, can OFAC, using the authorities it cited, properly add this to the sanctions list and block these things?
No. To my reading, and this is just a plain meaning reading of IEPA, IEPA allows you to block property in which foreign nationals have an interest. That's the quote.
Yep.
That's the statute. Now, you might want the statute to be broader or different if you're the administrator tasked with taking strong action against a tool like Tornado Cash in the world, but you can't change the statute. You have been given or delegated powers, enumerated powers from Congress in the statute. You are supposed to operate within those powers. If you start doing things that Congress didn't say you could do, you're rogue. You're out there operating outside of the law.
Right.
And then someone maybe brings a claim and says, you've exceeded your statutory authority. You're doing things that Congress never sent you there to do.
Okay, so then let's just get straight to that. There are other claims that can be made. So let's save those for the end and just say that in this case, somebody's got to bring a claim. And Coin Center is now exploring how to do that. And I say we're exploring it because we have to talk to counsel to figure out who would be best positioned to do that. I think, we certainly, I think, would have standing. In the past, before this thing was sanctioned, Coin Center has received donations via Tornado Cash. Somebody wanted to keep their anonymity when they sent us donations. And in the future, we may want to use it. In fact, we want to use it. I'll tell you right now, in the future. And so I think that gives us standing enough to do that. But there might be other folks who are more clearly have standing, right? So folks who in the past have used it a lot and intend to use it.
Or may even have funds currently at the contract address, which only they have the power to withdraw. And so we know that, this gets to another thing we didn't discuss, but in the traditional OFAC investigation context,
I want to get to that. I'm sorry, but I'm staging. So it could be people who. So we have used Tornado Cash in the sense that we've received from it in the past, but there might be people out there who actually have used it to send to somebody else or to themselves funds to protect their anonymity. There's that set of people. As you say, there are people who have used it and were using it when the sanction happened, and so now have funds trapped there. And there are people who, subsequent to the sanction, have been, quote unquote, dusted, which means that somebody has begun to send small amounts of ether from Tornado Cash because it's immutable and it's running and it's unstoppable. It's still working, right? Yeah. And so somebody has been sending to known Ethereum addresses, including celebrities, right? So Jimmy Fallon, Shaquille O'Neal. I know our friends from Bankless received some of this ether.
Especially folks who had a .eth, which means their Ethereum address because it's like Valkenberg.eth, or people who got really into the NFT thing and were like, "Hey, look at my Dickbud avatar." It's like, oh, now we know your address.
Yeah,
we'll send you some Tornado Cash.
So these people, all of these people, could be plaintiffs in this case. And if you are one of these folks, if you find yourself in this kind of situation, please reach out. Because it may be, we might be able to work with you.
And it would be advantageous to have a broad tent of people who want to challenge it because they're eligible to challenge it, which means they have standing, which is the legal terminology here. And any kind of injury is standing in this case. Like, now I can't get my funds. That is an injury. Now I can't use it in the future to maintain my privacy. And I have a track record of using it in the past. So you believe me, that's an injury. Even these folks, I don't know if Jimmy Fallon's going to watch this right now, but if he did, or if his lawyers watch this, the fact that because they've received funds means they already have obligations. Within 10 days, they need to tell OFAC, I've received property from an alias that you've got on the SDN list. What do I do? The fact that they're now obligated to send a notice and report, that is also an injury. That is something that they can actually bring as evidence of standing.
So, we're in the very preliminary stages of figuring all this out. But if you know us, we've sued Treasury before, and I guess if we have to, we'll do it again. And so reach out is what I'll say. Now, moving on from that, there are people who are going to have other claims. So, for example, somebody, and by the way, what we're suing for, if and when we sue, it will be to say to a court, OFAC exceeded its authority. So it can't do what it did. So that's what we'd be doing. But separately, there are people, as you say, for example, who have funds locked in the smart contract now that they could, very easily retrieve. But if they do, it seems like they would be violating the law, or at least OFAC certainly will see it that way. And so people now are kind of stuck. And those people could bring a claim, but before they can bring a claim, they might want to exhaust their administrative relief avenues. And so they might file for a license. either for themselves or the DeFi Education Fund has announced that it will be seeking a general license, which means OFAC has the ability to grant a license to a class of similarly situated folks so that they're excused, they can retrieve their funds. And it'll be interesting to see.
This would be like, I think it's easier to speak.
Well, I was going to say, yeah. So
okay.
I'm getting to where you want to go.
Get them faster.
No, I'll be slow. Yeah. So what you want to say, Peter, is in the past, OFAC has found itself in a similar situation where, for example, it wants to designate a bank. Wants to sanction
a Honduran bank, for example.
A Honduran bank, right? That maybe was engaged. It was just, the owner of the bank was corrupt, et cetera. And so they want to sanction the whole bank, not an individual person, but the bank. Mm-hmm. But as it turns out, there are going to be dozens, maybe hundreds of Americans, completely innocent, who happen to have accounts at that bank. And mm-hmm. once it's sanctioned, Americans can't withdraw their funds, but they've got mortgage payments to make.
Yep.
So what does OFAC do in these circumstances?
So from our understanding, because we've talked with people who've worked there in the past, is like you will literally potentially have a situation where OFAC examiners, specialists, agents are getting on a plane in the middle of the night to go to Honduras, in this case. And they need to do this because they need to work with the Honduran government, and they need to work with the bank, which might now have new directors. You've gotten rid of the criminal directors, and now the bank's kind of clean, but we have to unwind carefully because we don't know, what nasty business these criminal directors were up to. And we probably don't want to give some of the money back to the people who put it there because they might be criminals as well. And so you've got the beginnings of a very sticky situation that requires a lot of sensitivity. And you've got these urgencies or these exigencies where you've got things like people who have to make mortgage payments in order to carry on their day-to-day lives and not end up in a really bad situation. And so working with the bank, with the local government, with US persons, things will happen. There'll be things like frequently asked questions will be posted. There'll be letters of
licenses.
Well, there's licenses. There's also letters of no need to comply or something like. It's actually
no action kind of stuff. Yeah,
no action kind of letters. You'll have licenses, specific or general, and all of this will have to happen. And it's part of the process that OFAC wants, because OFAC, as it says in several places, including the Tornado Cash press release, our power is not just to punish.
Not just not to punish. They specifically say our goal is not to punish.
Yeah.
Not you said not just. There's no just involved. They say their goal.
To me, that's a little too cute because I'm pretty sure they're also punishing. But fine, they say their goal is not to punish.
Not to punish, but to change
behavior. And so the process of getting on the plane and working with the bank and the local government and the Americans is to change the behavior. And so in this case,
well, and just to take a step back, because you said it's a process. The first step in doing all of that is recognizing that, this is a case where we're going to affect potentially dozens, hundreds of innocent people, Americans or not. We're going to affect them negatively. Mm-hmm. And therefore, we should take all these steps to mitigate that you're describing. And that's what we understand is called a collateral impact analysis, that when you're about to designate somebody, you do to assess what collateral impact the action you're about to take has. And you should be able to see, this is going to potentially hurt or affect a lot of people. Let's take these mitigating steps. Mm-hmm. So in this case, it's clearly it's affecting all kinds of people, right? So it's certainly affecting, number one, people who have money there right now, which includes lots of just Americans. It is affecting people who are using Tornado Cash, which again is a tool. It's not a person or anybody's property. Are using Tornado Cash to maintain their own privacy, and because they have a constitutionally protected right to do so if they want to. Okay. And it's affecting people who since then now, might get quote unquote dusted.
Yeah. And so And so,
and can I say one more thing? And this was all completely foreseeable.
Yes.
Anybody who knows just the slightest thing about crypto, they would have seen that all of these circumstances.
Yeah. And we bring all this up for a couple of reasons. All of these internal processes are intended for harm reduction. We're achieving important national security objectives, but we don't want collateral damage. But they also serve a legal purpose. And that's because if we're talking about like Americans who can no longer make their mortgage payments in time, we're talking about an actual deprivation of liberty or property, right? We're talking about real harms to Americans. And under the Fifth Amendment of the Constitution, which is the Due Process Clause, any deprivation by the federal government of a person's life, liberty, or property must allow for notice, the opportunity to be heard, and a decision by a neutral decision maker. And sometimes that usually has to happen in advance. Like before you can be thrown in jail, you need a trial and all that. You at least need notice. In certain exigent circumstances, notice can come after the fact because the government says, well, we give people notice and they're criminals, they'll just run, or they'll move the money before we can lock it up. But even in those situations, some sort of process is necessary after the fact. And in the extreme circumstances, even if there's an American involved, courts occasionally defer to the executive and say, you know what, we've got a different test for due process. And from what I understand, and I'm just starting to dig into the case law, these are the Matthews factors, which is a balancing test that says, look, government's got a strong interest here because of something like we're at war or there's a cyber emergency. We need to balance the procedures that the government has offered rather than the traditional notice and public hearing, and the value of those procedures against the typical procedures with the national interest in mind, and do a balancing test. Like we're willing to accept slightly reduced due process protections, but it's still got to be something. And this is why we're talking about all of these things that OFAC typically does, is because we don't know. I haven't seen a collateral impact assessment. Granted, those would probably usually be private, but we'll see if they did one.
Well,
we'll find out. And I know for a fact that a lot of the steps, putting the guys on the plane to Honduras, is not something that's even available here because, again, these are robots. It's not as if you're going to convince the robot to release the Americans' funds. It's going to be stuck there unless the American has a general license to remove. So yes, Americans will have to exhaust their administrative remedies, but if they exhaust their administrative remedies to get a license, then there's a real due process claim there, because effectively all of the normal procedures internal to OFAC that normally would have protected these Americans from deprivations of their liberty or property seem to have failed to do so. And so we'll run that balancing test again, and it could still come out that, the North Korean threat is so grave that all these Americans are SOL, but that's going to be up for a court to decide on due process grounds, on constitutional grounds.
Right. And again, we don't know what process or what procedure was followed here, because this is all done behind closed doors. But certainly what we can say is that, I don't see any evidence of it, or at least of a collateral impact assessment that was reasonable, because any reasonable assessment here would have had anybody foresee all of these things that we've outlined, right? So yeah, I just don't see evidence of it.
Yeah, and so this due process claim is something that aggrieved Americans could bring. I think it is a claim that goes along with our statutory claim, because we want to bring multiple claims, and our inability to use tornado cash in the future, and if we can't get a general license at some point, that is a deprivation of liberty. And also, when you bring a statutory interpretation claim, and there's a bit of a schism amongst the judiciary as to the best way to interpret statutes. The more textualist, originalist justices and jurors will say we should just look at the words of the statute, a plain meaning rule, and that was our case earlier. Is the plain meaning of property in which a foreign national has an interest. Plain meaning of that doesn't include a smart contract on the Ethereum blockchain that no one controls. But if you don't have a judge who wants to do a plain meaning analysis, they'll often do things like look at legislative history, but also at other substantive canons of statutory interpretation, which means we're injecting some sort of more than just pure logic, but sort of subjective moral sentiment into our statutory interpretation. And the big one here, to me, is the constitutional avoidance canon, which says amongst two ways to interpret a statute, broad or narrow, yes, it could include Ethereum addresses that no one controls. No, it couldn't. It's only about property of a foreign national. Between these two ambiguous choices, to the extent we think they're ambiguous, you have to choose the one that avoids constitutional harms, that avoids constitutional questions even. So this is the constitutional avoidance canon. And this due process claim comes right up if you choose this broad interpretation. So it actually says to a judge, you probably should choose this other interpretation. It's persuasive in that sense. And there's another constitutional claim, or sort of there's a looming constitutional issue. If we start going down a road where the SDN list is populated with all these autonomous pieces of software as they exist on the Ethereum blockchain, we basically switch the default rule. We're saying, we went from a world where we're saying you can use whatever software you want, no prior restraint, to a world where this whole list of software you can't use,
Unless you get a license from us.
Unless you get a license from us. You still have remedy. You could go through this administrative process and get a license to use this particular smart contract and the open source software that resides within it. That is a prior restraint on certain types of speech activities. It is at the very least, even if it's not a prior restraint, because you're saying, well, you can still copy and paste that software. You can still look at it, just can't use it. At the very least, it's a significant chilling of constitutionally protected speech, because basically you've created this name and shame list of open source software, and we know what's going to happen. All compliant US businesses who are scared to death of the willful OFAC violation penalties, which are like 1.5 million per violation, 30 years in jail, will be like, we're just not going to publish the software repository anymore, because we're not sure if you're not supposed to deal with the Ethereum contract address, or really just that's just an avatar for the open source software itself, which we're then not going to publish either. So you get this substantial chilling effect. And there's another thing, and we don't explain this in the post, so I want to just say it real quickly. On the First Amendment grounds, all of those transactions through Tornado Cash that were legitimate, like donations to Coin Center, a nonprofit, were also, I think you can make a strong argument, constitutionally protected expression or constitutionally protected speech. You look at Citizens United, you look at Buckley v. Vallejo, where donations to political causes are considered protected speech activities. And this is, in effect, a blockade on making private donations to organizations like Coin Center. Now, it's not a complete blockade. You could say, well, you're not allowed to use the Tornado Cash thing anymore to donate privately to Coin Center, but you've got 5 other ways. At a certain point, the SDN list gets long enough, so this goes to the chilling effect again. You're burdening, you're getting at legitimate things. You're really trying to stop North Koreans from using it, but your law is so overbroad that it's burdening enough constitutionally protected activity, like donations to Coin Center, that it's no longer acceptable under the First Amendment. And this is generally referred to as the chilling effect. And there's lots of case law that shows that even if the law has a really, completely legitimate purpose, if it's construed too broadly or written too broadly such that it burdens all of this constitutionally protected activity, it can't stand.
All right. And the other thing that can't stand is us going on any further. So
hey, we're under an hour though, right? That's good.
I think if we stop right now, we might be.
Niraj is like, I hate you guys. You're supposed to do it.
Yeah, Niraj said, can you guys keep it to 15 minutes? And we laughed and laughed. Yeah. All right. I think that's it for now. Stay tuned. We're going to try to make this podcast more regular, I hope.
It's become more regular because it's become the emergency podcast.
I hope I don't.
And there's just always emergencies now.
Yeah. But anyhow, thanks, Peter, and see you guys next time.
Yeah. Thanks, Carrie.